Whoa. Start from the jump. We're diving right into the judge's cross-examination of Ms. Shepard, who's in court for unauthorized use of a vehicle UUV, a serious felony charge. When a judge asks what's wrong with your life, it sets a dramatic, high-stakes tone right away. This isn't just about the car. It's about the bigger picture.
What are you doing? What's up wrong with your life?
Well, she left out the fact that she sent me up there to pick my mom's ashes by myself. And I just
No, don't. Here's the thing.
I know it's wrong, but I just was upset.
No.
We were arguing.
Why should I not just revoke her? She didn't show up. She didn't do anything. She disappeared, and all she did was pick up a new offense. So why shouldn't she be revoked? She can find her way to the HEB. I know she could have found her way to probation.
Spit the gum out, man.
You chewing gum?
Your attitude toward me right now, Mr. Alexander, it really, really sucks.
If you're in a relationship with somebody and you start wanting to search their phone, then that means that there's no trust in your relationship, and maybe you shouldn't be in that relationship. All right, here's the thing. At some point, like I know people have rough childhoods, but at some point, it's no longer your childhood's fault. It's you.
Courtroom 101. Dress code. This is a classic moment. The judge is firm but fair, using it as a teachable moment. It might seem minor, but presentation matters. It shows respect for the court and the severity of the charges. Quick poll. Does the defendant's outfit actually impact the judge's ruling? Let me know in the comments.
All right. That's okay. I always tell people everything is a learning process. If you know better, you can do better.
I kind of knew, but I kept a friend of my mom's last night, and I had court this morning, and I didn't have anything else to wear, and she went.
All right. So,
I apologize.
no problem. So next time, I always tell people I'm not expecting fancy dress. They don't have to be suit and ties unless.
I figured I'd show
Yeah.
I better show up anyway.
No, that's good. All right. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. However, the court will defer finding the guilt as you apply for deferred adjudication. Are you proceeding with sentencing? Anything you wish to say on behalf of your client? All right. What is going on in your life, Miss Shepard, that you're taking your sister's car? I mean, I read in the police report that your sister was sick at the time. She gave you permission to go to the grocery store to pick up groceries, probably soup and some Jell-O and popsicles for her, and she's sick. And then you come back, and then you take a car again without her permission. And then she's calling you to bring her car back, and you're like, I'm down the street, I'll be right back. And then you don't come back. What are you doing? What's wrong with your life?
Well, she left out the fact that she sent me up there to pick my mom's ashes by myself. And I just
No, don't. Here's the thing.
I know it's wrong, but I just was upset.
No.
We were arguing. And son and I was coming, and then I was sitting down there, and we kept arguing on the phone.
Here's the thing. Your
Your
sister.
The ashes and alleged theft. This is the emotional core of the case. Ms. Shepard is trying to pivot from a UUV charge to the emotional distress of her mother's passing and a dispute over ashes. The judge cuts her off because the theft is distinct from the familial grief. The defense strategy here is to garner sympathy, but the judge is laser focused on the crime.
It over the top. You know the reason why they're taking it over top? Because they're guilty about something. Maybe they didn't do what they thought they should have done when the person was alive. Well, you know what? You got to get over it, because guess what? The person is no longer alive. And whatever you didn't say and you should have said, you can pray or whatever to whatever higher power you believe in, and hopefully it reaches your relative. But I guarantee you, the relative who passed is enjoying their afterlife, and you can't undo what you did do and what you didn't do. So, are there drug issues with you? No, you say not no more. What does that mean? What? Taking what? When's the last time you used? All right. So why are you driving around with your mom's ashes and you on crack?
I took the ashes. I took the ashes out the house. And then I was just sitting there reading the books, and I just got mad. And then I didn't want to come back when I was getting high, so I wanted to keep the car. So when I would come down, I was going to take her car down, which I did. I went back and put gas in, and I was on my way back home. I just wanted to come down.
I've never known anyone who's in their addiction.
The crack cocaine admission. Wait, what? This just escalated the case dramatically. The defendant admits to using crack and stealing the car to use it, contradicting her initial denials. The judge's skepticism is palpable. This admission is a foundation for the eventual terms of her deferred adjudication, mandatory drug court, and in-custody evaluations.
With crack cocaine or anything, decide to take a car and then fill it up with gas and bring it back.
He was at the gas station. That's where they stopped me.
All right.
I know it was crazy, but that's what I did.
Are you employed?
No, man.
How are you supporting yourself?
I just came from my TP. I just I got an interview with.
So how you been taking care of yourself? That's my question.
I've been staying at TP, and I've just been going and helping this miss out halfway and helping her at the house, and she couldn't do it. And then we stayed there, and I couldn't pay for it.
What, are you a home health care provider?
Yes, ma'am.
Not anymore. I don't allow that. You're gonna have to get a job.
Yes, ma'am. I have an interview with Dr. under the weapon. So tell me one thing.
Okay, well, let me just tell you, I don't allow people who are on probation out of this court to be home health care providers. So you're not going to be doing that. The fact that you took your sister's ID and medication, no, you cannot be a home health care provider. So, do you have any children?
Yeah, bro.
All right. This is what the court is doing. 2 years deferred adjudication, $1,500 fine probated. Take in consideration 2022 CR 5672. There's to be no contact with Otto Harrison. All right, and Mr. Cox, have you spoken to Miss Lewis? All right, so do we even know if she wants to have contact with her sister? I'm going to do no contact. Sometimes, once you're on probation for about 3 months, then the court will reconsider. But I can't have people who are enablers for people. Like, her sister never should have let her take the car in the first place, even though she was ill and she was just supposed to go to the grocery store. So there's going to be no contact with Otto Harrison and no contact with Lola. You know what I'll say? I'll say no in-person contact with Lola Lewis. You can call her on the phone, but you're not allowed to have face-to-face contact until further notice. So y'all can call on the phone and you can FaceTime her. You just can't contact her in person. There's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Field visits 2 times per month. I'm going to want a TAP evaluation. And if the TAP evaluation recommends inpatient treatment, we'll start off with outpatient treatment. And I'm going to want a referral to felony drug court. So if felony drug court accepts her, that's where you'll be for 2 years.
Okay.
100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get COVID vaccination, but if you do, you'll receive 40 hours credit. There's to be regular reporting to probation by Zoom or in person, and regular UAs. Probation, is there anything else she needs? Intensive outpatient treatment. But I want her referred to felony drug court first. And you know what? We'll do field visits 2 times per month until further notice. Is there anything else you need from the court? Does that cover it? Yep. And I'll recall the warrant. You're welcome. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. You got to do better. Because your mom is no longer with you. The only family you have is, your sisters and everything. So here's the thing. With your sisters, y'all supposed to be sticking together, looking out for each other. All right. Okay, good luck to you. So we are going to recess, and we're going to be back at 2.
Thank you.
PR 5306, State of Texas versus Mary Luella Shepard. Could I have parties announced for the record for the state?
It's for the state, Your Honor.
Defense.
I was for the defendant.
And are you Miss Shepard?
Yes, I am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, I did.
Are you the same Mary Luella Shepherd who was placed on deferred adjudication in 2022 CR 5306 for the offense of unauthorized use of a vehicle on August 30th, 2022 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bear County, Texas. The defendant, Mary Luella Shepherd, did then and there fail to report to the supervision officer as directed for the months of September, October, November, and December 2022 in violation of condition number 4.
How do you plead to that? True or not true?
Not true.
State.
Violated condition number 1 on or about the 14th day of October 2022.
I'm sorry, I don't have a supplemental.
Sorry, it's in the supplemental.
All right, did you review the document entitled Supplemental Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, I do.
All right, you may proceed.
Violated condition number 1 on or about the 14th day of October 2022 in Bear County, Texas. The defendant, Mary Luella Shepherd, committed the offense of theft, $100 to less than $750 in violation of condition number 1.
How do you plead to that? True or not true?
Your Honor, we waive the other violations alleged in the motions.
Any objection? All right, did you understand by pleading true to violation of conditions 4 and 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, I do.
Knowing that, do you still wish to plead true to violations 4 and 1?
Yes, I will.
Court will find 4 and 1 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you deny the motion to be defendant on probation and extend probation for 1 year. We're asking that she can sign her conditions of probation in court today and follow the recommendations of the TAP evaluation, which are to provide proof of completion of the Haven for Hope's integrated treatment program and the outpatient treatment program with BCC SCD with monthly urinalysis and documented sober support meetings. And also the state is going to TIC County Court number 11, cause number CC 711696.
All right. Is this, you're asking the court to follow this?
Yes, Your Honor.
Probation?
Sorry, Judge.
Yes.
Also, no contact with HEB at 4100 South New Providence.
Probation?
Yes, Your Honor. Ms. Shepherd did not show for her initial intake for her original term of probation. So we would ask that we extend for the 1 year to take account of that and then follow all of the TAP recommendations.
All right. Does your client have any mental health issues?
I don't believe so, Judge.
So why should I not just revoke her? She didn't show up. She didn't do anything. She disappeared and all.
Second chance denied. This is the second court appearance for Ms. Shepherd, where she's violated her initial deferred adjudication. The judge is right. She failed to report and picked up a new theft charge, finding her way to the supermarket HB, but not probation. The defense argued for an extension, but the judge gives her 200 days in jail. She burned her second chance. This is how deferred turns into conviction.
She did was pick up a new offense. So why shouldn't she be revoked? She can find her way to the HEB. I know she could have found her way to probation. So why should I give her another chance? She hasn't done anything except picked up a new case.
I believe she will follow the recommendations of probation at this point, Your Honor.
All right. The court is going to grant the motion, find you guilty. Does anyone want to speak to a sentence? I'll sentence her under 1244. And I'll sentence her to 200 days at the Bear County Jail. Is there anything else? And the court will take in consideration 711696 and give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. You have a limited right to appeal. And that right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right. We can go off the record. Ms. Shepherd, I want to let you know I did listen to the recommendations from the state and the agreement that was made,
Yes, ma'am.
but You haven't done anything. You didn't report. You didn't do anything.
I understand.
All right. Okay. Good luck to you. Okay.
Thank you.
You're welcome. Understand what you're charged with by indictment is assault, family second offense. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Want an attachment, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor, my client requested probation because he does realize he needs help. He specifically asked for that, and that's something that is rare, that people ask for help when they do need it. In addition, when I was conferring with the state, and it's not on the paperwork, we were also asking that there be a McMyoff evaluation, because my client has indicated that he does believe he has some mental health issues and he would like help.
All right, Mr. Moore, how old are you?
I'm 29.
All right, why do you keep hitting on people?
I'm starting to believe it's just because that's what I saw when I was young, you know?
All right, here's the thing. At some point, like I know people have rough childhoods, but at some point, it's no longer your childhood's fault. It's you and your choices you're making. So are you currently in a relationship?
No, I'm not. I've been single since I've been released. Right now, I'm just working and just trying to do the next best thing I can.
All right, what do you do for a living?
Right now, I'm working at Sterling's Foods. It's a bakery.
Okay, how far did you go in school?
I went all the way to the 12th grade, and then I had to get my GED. I had some disciplinary problems at that point, too.
All right, so where are your parents?
My parents are both in Michigan. Both of my parents are struggling with their health. My mom was a drug addict for most of my life. She's been clean the past few years. And my dad his health deteriorated when he had a stroke and fell and hit his head.
All right, so do you have any children?
Yes, ma'am, I have 4.
What are their ages?
4, and 2 and 1.
And are these different mothers?
I have 3 by one and 1 by another.
Okay, who is it? The 4 and the 4, are they twins?
And no, those are the 2 who have different. That's where the line was made.
All right, so where are your children? Are they in San Antonio or somewhere else?
They were in San Antonio when I got arrested. I'm not sure where they are at this point.
So is Child Protective Services involved?
No, ma'am. They weren't a part of it.
Well, I mean, sometimes children are a part of it in different ways when we don't think they're a part of it. Like maybe your child is not a part of it because nobody physically hit them. But you're saying you saw certain things in your childhood, and that's the reason you are the way you are. So the same way that your children may see things, and that may be the way they may become if you don't change. You understand?
Yes, Sharon, I do.
I can't force people not to be in relationships, but it seems to me as though you should not become involved in another relationship with anyone until you complete the work that you need to do on yourself. You understand?
Yes, Sharon.
I can't force people to stop having children, but it seems to me that until you finish and complete the work on yourself, just maybe, I tell people every day, children can't raise themselves. Like you're not in your children's life. And sometimes men, sometimes women, when they're not and they're involved in their children's life, they're like, oh, well, the grandparents have it, or, oh, the other parent is taking care of it. But you're supposed to be taking care of it. Because guess what? Your 2 4-year-olds, your 2-year-old and the 1-year-old, you can't just put them at Travis Park and say, I have produced you, go forth and get your milk, diapers, or whatever, your Pampers, and go forth on your own. The 2 4-year-olds are not old enough to take care of the 2 and the 1-year-old. So now they're just out in the world and their father's not with them. So you're going to have to start changing your ways and do better. You understand?
Yes, I do, Your Honor.
All right. If you're drug tested today, what are the results going to be?
Negative for everything. I haven't done any drugs since I've been released.
All right. What drugs did you do in the past?
Marijuana, ecstasy, and methamphetamine.
All right. I don't know why. Do young people not watch TV? Maybe they don't, but I'm sure everyone knows. I don't know why people get a certain age and they decide they want to try meth or heroin. People need to stop doing that because it leads to no good place. All right, this is what the court is going to do. The court is going to sentence you to 7 years in prison, suspended and probated for 7 years, $1,500 fine, probated. Take in consideration 2021 CR 8905, permanent finding of family violence, no contact with Treasure Barnes. Do you have any children with Treasure Barnes?
No, I do not.
So you shouldn't have any, there's no need to contact her. $100 to a family violence center, 120 hours, community service restitution. I'll deduct 40 hours if you obtain the COVID vaccine. I'm not forcing anyone to get it, but if you do obtain it and provide proof, 40 hours will be deducted. And I'll also deduct the remaining community service hours, Ms. Reyes, if he completes some sort of trade school or goes to some sort of higher level of education. We'll do a MIC evaluation.
Okay, thank you, Jan. I was just going to ask what exactly that was.
Oh, it's an intensive course to help you with any anger management issues you may have. Regular UAs, or you can do the patch. Rebecca, is there anything else Mr. Moore needs?
No, ma'am, that's it.
Mr. Moore, is there anything else you need from this court in order to be successful?
No, Your Honor, I think you just covered everything. Thank you.
You're welcome. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and also because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I do.
And also because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, I do, Your Honor.
All right, we can go off the record. Mr. Moore, you can't have anger issues combined with drug issues and raise children. Because the next thing you know, children is on the news because they've been abused, right? So
Yes,
if you're going to do right, then do right. If you're going to be in the children's life, do right being in their lives, right? They don't need to see violence. They don't need to hear arguing or shouting. They don't need any of that. Because believe it or not, that affects them, okay? And do you want to hear and did you hear my orchid speech? Oh,
no, Your Honor, I did.
Brenda, he did not hear the orchid speech. Okay, here's the orchid speech. For Boss's Day, I received an orchid. And I appreciate them because they know I love plants. But they gave me orchid, which is one of the most difficult plants. You have to be like a master gardener to make an orchid bloom. So when you get an orchid from the grocery store, it's like $12. So you can pick up one from Walmart or HEB or one of these stores for $12. It's all beautiful. It's in bloom. When you go to the store, you're trying to figure out, do I want the purple one? Do I want the white one, the blue one? Which one I want? Get an orchid. If once the blooms fall, which they will, upon the falling of the blooms, if you can make that orchid bloom again without buying a brand new orchid, grasshopper, then you will be ready for a relationship. Grasshopper is from carotene. I know the young people don't know that. But so don't get into a relationship until you get an orchid, the blooms fall off and the blooms come back. Because let me just tell you about an orchid. They give you all these instructions. You can't give it direct sunlight, but you got to give it enough sunlight. You can't overwater it, but you got to give it enough water. Don't move it around a lot. So all of this, orchids require tenderness. They require you to show love. Sometimes you have to talk to it. It still doesn't help. So once you're able to do that, then that means you have patience and you're ready for a relationship. Understand?
The legendary orchid speech. We're ending with Judge's signature wisdom. This is a fantastic, unexpected way to emphasize the work required for self-improvement and healthy relationships. It's a powerful metaphor. Like an orchid, a relationship in recovery requires extreme patience, tenderness, and specific conditions. A perfect, relatable takeaway for the audience after a heavy case.
Yes, I do, Your Honor.
All right. He says are you going to do that though?
Yes, I might actually do that.
No, do it. I'm telling you. Yes. And once the blooms fall off, then if you can make it bloom again, you're ready for a relationship.
Okay.
All right. I'm going to send you. That. All right. I'm going to send you to breakout room number 2. Miss Valenzuela, if you could go to number 2. Court is calling 2021 CR 8754, State of Texas versus Aaron Jamal Moore. Can I have parties announced for the record for the state?
Allie Jackson.
Defense. For the defense?
Catherine Valenzuela.
Are you Mr. Moore?
Yes, Your Honor.
All right. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Aaron Jamal Moore who was placed on community supervision in 2021 CR 8754 for the offense of assault family's second offense on October 26, 2021 for a term of 7 years? Is that you?
Yes, Your Honor.
State?
Your Honor, we're proceeding on violation of condition number 2, that on or about the 24th day of November 2021 in Bexar County, Texas, the defendant, Aaron Jamal Moore, did then and there fail to submit to drug testing as directed by the court officer or supervision officer and or duly recognized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
That's true.
All right. Off the record for a moment. Defense, if y'all move down to that end. All right, we're back on the record. State?
We would waive the others.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, and sentence you up to 7 years in prison and up to a $1,500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is a proposed agreement, Your Honor. The proposed agreement is that we alter and amend for a mental health evaluation in TAP in custody. According to the notes of his probation officer, when he last appeared back in 2022, he was talking about he was feeling that he was going to relapse. And it seems that that's what he did. He absconded in relapse, Your Honor. That's why they're recommending that we do the mental evaluation in TAP while in custody.
All right. Are you asking the court to follow that agreement?
Yes, Your Honor.
Mr. Moore, are you asking the court to follow that agreement?
Yes.
Defense, anything you wish to add to the record?
Yes, Your Honor. Just for further clarification, Mr. Moore, we have discussed that he does indicate that he did indicate to probation that he did have mental health concerns. He was very troubled about, well, especially his grandmother being ill. She passed away last year, 2023, and he was picked up and has been held in custody since July of 2023. So he's been in custody this whole time. So he hasn't.
Well, you're not saying July of 2020, correct?
Correct, Your Honor. So yes,
24.
you're right. I know.
Okay.
Yeah, there's.
July 2023, Your Honor.
Yeah, we're not. But I mean, it just.
He's been in other jurisdictions.
He's been in other jurisdictions. Yeah, so it's not. We're arguing the length of the time, not that there was time that.
All right. So when you say he's been in other jurisdictions, is that for other cases?
I believe so, yeah.
They're not alleged in ours. I haven't received any evidence about them.
All right. What are these other cases? And the reason why I'm asking is because depending on what the recommendations of the TAP evaluation will be and what the recommendations with regards to mental health will be. If he has outstanding cases in other counties, they're not going to accept him.
No, I believe he has disposed of all those
Yeah,
cases.
I don't have anything
And-
outstanding.
And they were old cases prior to the pendency of this case, Your Honor.
Yes, Your Honor.
All right. And when we say he's disposed of those cases,
He served time.
are we taking Mr. Moore's word that he has disposed of those cases, or do we independently know?
I do.
And Mr. Moore, I want you to let you know, I'm not saying that you're being dishonest, but sometimes what the accused think of as disposed, sometimes it's not really disposed of. So does anybody know?
No, but he was brought over while in custody. I mean, so he transferred from their possession to San Antonio's possession, I would believe. Typically that they don't bring them over if it's okay.
No, that's
Okay.
not true.
Yeah, I'm saying that sometimes we ask for them or other things.
All right. Probation, what is your recommendation?
Judge, according to the court summary, it is what has been discussed, the mental health evaluation and taxing will follow all recommendations.
Well, what is TAP?
All right. This is what the court is going to do. The court will deny the motion, alternate amend conditions to include a mental health evaluation and TAP evaluation. That is to be in custody. He's not to be released until the mental health and TAP evaluation are completed and to follow all TAP recommendations. So if TAP evaluation recommends that you're to be in inpatient treatment, you're going to be in inpatient treatment. Do you understand?
Yes. Could you expound on like specifics of inpatient? I'm a little bit.
Oh, so if you have a drug or alcohol problem and they deem that the only way to help you is to place you in an inpatient facility, similar to the Betty Ford Clinic. Have you ever heard of the Betty Ford Clinic? All right.
Wow.
It's the Bexar County version, right? So if they deem that you need inpatient care to address mental health issues, to address any drug issues, then you're going to go from the Bexar County Jail to whatever inpatient treatment they recommend.
Okay.
If your attorney feels as though inpatient treatment is not appropriate, she can always come back and the court will hear it. Do you understand?
Yeah.
That's yes.
Yes, Your Honor.
All right. We can go off the record. In this court, communication is key. I do appreciate the fact that you picked up the phone, that you called your probation officer and said that you thought you were going to use or that you were having issues. That's a good thing that you did that. Next time when you pick up the phone, well, I know there won't be a next time. But if you pick up the phone and call them and you have an issue and nobody gets back with you, come to court and we'll address it. Okay?
Okay.
All right. Anything else?
Nothing for the.
So will I have another court date?
No, not unless your attorney requests it.
Oh, okay.
Yes.
So
So this case has concluded as far as the allegations that you violated your probation.
Okay.
The
So
only way you'll have another court case with me is if you pick up another motion to revoke.
okay. So at this time, I'm just waiting for evaluation.
Yes.
Okay. Thank you, Your Honor.
And the probation officer will be able to tell you when your TAP evaluation may take place.
Okay.
Thank you.
Thank
Your Honor.
And Judge, she's a court case needs to confirm.
Yes.
And we
And,
understand that.
yes.
We will-
And then you have a county court at law case to take care of. Here's the thing. Any cases that you have pending and are open, if you're recommended for inpatient treatment is not going to transfer you to inpatient treatment as long as you have cases that are open. So you have a misdemeanor case, the DWI case.
Mhm.
If that is not taken care of, they're not going to transfer you.
So I'll be in limbo until I get that done.
Yes.
Correct.
Okay. Thank you.
When,
All right. You're welcome.
thank you. Your Honor.
Thank you. Anyone else ready?
I'm ready.
Please, that they're working on it.
All right. Thank you. Paul Padilla.
Mr. Alexander, are you here with anyone today?
Yes, sir.
Who are you here with? Go grab her, please. Go grab your mom.
Your mom? Yeah, come on up.
Come on up, Mom.
Good morning.
Hi. Thank you so much for coming. Did you hear everything that happened?
Some of it, I couldn't hear all of it.
Let's hear it again. Okay, do you mind, please?
Yes, Your Honor.
Thanks.
On September 23rd, officers were dispatched to 11910 Chetman Drive in Harris County, Texas. The complainant, the mother of the 13-year-old boy, told the officers that her son was riding down the street riding his bike. when the son passed the defendant. The complainant and the defendant know each other, and when they passed, the defendant began insulting the son, and the defendant pulled what appeared to be a tan handgun from his waistband and pointed it at the complainant while making remarks about shooting him. After the complainant told his family about what happened, they went to look for the defendant and confronted him. The defendant reached into the waistband again, but the complainant's family was able to wrestle away the gun, which turned out to be a BB gun. The officers noted the BB gun appeared to be very similar to a real gun in appearance.
Look, he's not charged with aggravated assault. You know, they could charge you with a very serious offense where you're looking at serious time in prison. You're lucky they didn't, Mr. Alexander. How old are you, sir? You're 18. What do you do with yourself these days? Spit the gum out, man.
You chewing gum?
Your attitude toward me right now, Mr. Alexander, it really, really sucks. You have an air of arrogance on you. Either that or... Has he been with you all morning?
I'm sorry?
Has he been with you all morning?
Yes, yes.
If I drug test you right now, what's going to show up, Mr. Alexander? What's going to show up? I'm sending him for a drug and alcohol test right now. I'd like to know what, if anything, is in his system. We have to... I don't even know what to say, but all I know...
I mean, you brought me up here, so do I have permission to speak?
Absolutely.
Okay, so respectfully, I would submit that these are the alleged charges. There is extenuating circumstances, and the report from the complainant is actually not accurate. That family has actually made verbal and written threats to my son, and we have proof of that. So while I understand that these sound quite egregious, it is not the whole story.
I understand. And I know that there's always two sides to a story. I get it. And you will have the opportunity. But within the first 5 minutes that I've met him, his behavior towards me, his demeanor, the way he looks, just...
That's anxiety. He's standing in the courtroom. He's standing in the courtroom for the first time. And he doesn't have his attorney. He doesn't have an attorney yet. And this is a process that's foreign to him. So what I would, implore from you is don't take his demeanor as disrespect. He is anxious. He's been anxious all morning. He has been with me all morning, and he doesn't really know what to say. So I understand that you're getting a first impression from him, but he is still a very young adult, and this is his first experience in a courtroom.
Right. I agree with you. Mr. Alexander, what you need to understand is that you're 18. You've got this bag of money on your neck, and this life is but a very, very short. Look at me. Look at me. This life is a very short one, and it can be a very happy life, or it can be a rotten, miserable existence of a life. What you do now will dictate the next 40 to 50 years of your life. You work hard now at 18 to 20 to 30 to maybe 40 so that you're not working like a dog when you're 70 to 80 and you can actually have a life and retire. This, by picking up criminal cases at 18, you're moving backwards. How far did you even make it in high school?
He's uncomfortable sometimes when you ask him to answer.
I want you to answer. I want to get to know you, Mr. Alexander. I want to know what's your... Sorry?
Said 11th grade. He said 11th grade.
You need an education, Mr. Alexander. If you're going to do anything in this life, you need an education.
I got my education.
I want to do everything I can to help you out. Okay? I really do. If he's smoking weed, it stops today. Okay? I'm going to drug test him right now because I want to know what, if anything, is in his system. If he tests positive, then I'm going to test him again in 40 days, give or take. The marijuana stops now. And I want him to get back in school. He either needs to be in school full-time or get a full-time job so that he's not running the streets. Mr. Alexander, I am also making it a condition of your bond that you're not allowed to have any kind of weapons whatsoever for any reason. I can give you a lawyer to try to help you out as much as I can, and I will waive all your fees so you won't be responsible for any cost for anything.
Thank you.
All I want is him to be as productive and as good of a person as he can be. And starting out with criminal cases at 18 and to where he can't even talk to me, we need to change that.
I just make a comment about the bond conditions.
Sure, of course.
I've done I called the complainant's mother in this case a few days ago and kind of spoke to her about what happened. And I learned that there is a history between this family and the defendant. Back in the summer, this defendant stole a gun out of the complainant's house. He asked to enter the house under the guise that his mother had kicked him out, went into one of the complainant's uncle's bedrooms and stole a gun. He FaceTimed the complainant's uncle a few days later, flashing the gun, telling them that he was going to come hit up the house while flashing the gun at him. They used to walk to the same bus stop. They used to come out of the same bus stop, the complainant and this defendant. The complainant is terrified of the defendant. We asked for no contact. We've also asked for GPS monitoring because of that. They don't attend the same school, but they were stopping at the same bus stop. Now the complainant asks that his uncle walks into the school bus every day because he is so scared of the defendant. And as I think is mentioned in the PC statement, the complainant in this case is 13 years old.
Was there a police report filed for that incident?
There was. I have the incident number.
For that one you're referring to about the gun?
Yes, where the gun was stolen.
What happened? They didn't follow it up. They didn't call the police. They didn't, theft of a firearm is a very serious felony.
According to the complainant's mother, they filed a report. She provided me with an incident number.
How long ago was this?
This was she said July. It was in July. I can attempt to follow up with the responding agency. I'm not sure if it was the sheriff's office or not, but I mean, either way, there is like a history between these two families. And the complainant and his mother are both in fear of the defendant.
So, Mr. Alexander.
I would again submit that this family lives around the corner from us. We have never been approached. He lives at home with me. In July, we actually were in Panama for his 18th birthday. We weren't even home. There was never a time he was kicked out of my house.
Were you out in Panama the entire month?
We were out in Panama from July 10th until the beginning of August. Yes. So
Well, that's not the entire month.
well, most of the month, excuse me. And in addition to that, there's no one has come to investigate anything at my house.
Okay, so Mr. Alexander, I'm issuing a protective order over this child, this other kid. You're not allowed to have contact with this person or go within 200 feet of where they live or where they work. Do you understand, sir? You're not allowed to be in possession of weapons. You're not allowed to have any kind of threatening or harassing behavior with this child. If they call back and they say that you have harassed them, then I will revoke the bond and I'm going to put you in jail. And I'm going to tell you now, I will not give you any more PR bonds. So all I'm asking you to do is stay away. No one is finding you guilty now. We're just asking that you guys separate and don't have any contact. That's it. I am going to put an ankle monitor so I know that you're not going anywhere near their house. But like I said, I'll cover the cost of anything, so it won't cost you guys anything. You must charge this thing on a daily basis, Mr. Alexander. If you don't charge it, the battery goes dead, then we will file a motion to revoke. Not a motion to revoke, but I'll revoke the bond. So as it stands now, what we'll do is I will send you now for a drug test. We're going to have you come back. I want to know what, if anything, is in it. And then I will provide you between now and then a lawyer, and we'll go from there. Do you have any other questions?
That family is in possession of my bicycle, not his, it's mine. They actually stole that from him. I would like my bike back.
There's proper channels to do it. I don't know how, but as it stands now, he can't go over there, can't have any contact with them whatsoever. You know, and I would venture to guess that if you go over there as well, it's probably going to be even more bad blood. So
No, I don't have any.
perhaps you can find someone else, like another intermediary, that can go over there and try to get a bike back. But at this point, just don't have any contact with them. And when you come back, then we'll have you speak to someone. Okay. All right. I'm going to have you sign a Go ahead.
Today.
Correct. Yes. Mr. Alexander, I want you to either get a job or get into school full time. But when you have too much time on your hands, you become self-destructive. Your brain craves activity. It needs activity. And when you don't challenge yourself with either school or a job or anything, then bad things are they're just gonna come and happen. You have to occupy your life. You have to do something. Where we're headed now, you're going the opposite way of how you should be doing things. This is not a good way to start at 18. All right. Please. Can you file a protective order, please, on the child? Thanks.
How long have you been disabled?
I've been pending disability for about 4 years.
All right. So in 2021, you would have still been disabled, right? So how heavy was the object that you took from the U-Haul?
The object was probably about like 30 pounds, maybe like that. Not even that.
Let me just tell you, if you can lift 30 pounds.
My problem is my back is bending over and walking. I can't be on my feet longer than 10, 15 minutes. I have to sit down.
But see, here's the problem.
Yeah.
You went to somebody's U-Haul at a hotel where you're staying. And according to the police report I read, you were lifting a heavy object. It states, suspect one, which is you, could be seen carrying a heavy object away from the U-Haul. So you had to carry it from the U-Haul to your room in room 1119.
No, ma'am. My truck was right next to it. And to be real, I was drunk. I was on drugs. So I lifted it and walked 5 feet and put it in the back of my truck.
So you lifted a heavy object,
like 25
walked 5 feet, 25. Well, you said 30 pounds at
30,
first.
25 pounds.
All right. So you walked from a U-Haul, lifted a heavy item, and you walked 5 feet. I'm not waiving his community service. And let me ask you, who is Tanganyika? Sorry, Diana, Tanganyika. Who is that to you?
That was an old friend. I don't even talk to her anymore. I haven't talked to her.
So you and your old friend,
2 years.
in 2021, you had a hotel room with that person and y'all were staying in a hotel room together.
Yes, ma'am.
And then you were still married at that time.
No, T knows my wife. Me and my wife were arguing. We call her name is T. I'll call her T. She got a room, so I had no money because I'm not able to work. So I was able to stay the night with her at the room.
And did she not have her own place? Or she just go around in hotel rooms and staying in them with people?
She's homeless too. Her parents kicked her out. She goes to hotel to hotel.
All right. Well, that's going to be between you and your wife after this probation is over.
My wife's already got into me about that.
Oh no, because I'm going to order the no contact. That's why I'm saying that's something that you and your wife will have to discuss after your probation is over. This is what the court is going to do. And cause number ended in 3-1. Court is going to sentence you to 2 years in the state jail facility, suspended and probated for 5 years. There's a $500 fine. I'll probate that. This is run concurrent with 2023 CR 0036. Take in consideration NIMAG number 7298876. There's to be restitution, if any, to Viviana Leyendecker. Cats 1 and 2. Cats 1 and 2 is going to teach you how not to steal, or at least tell you don't steal. There is to be no contact with TANGANYIKA. Last name ROLNIK. Right, and cause number ending in 36. Court is going to find you guilty. Assess punishment at 5 years in the prison, suspended and probated for 5 years. This is run concurrent with 2022 CR 7131. Take in consideration NIMAG number 729875, 729876, grand jury number 804891, the BIPP course. There's an affirmative finding of family violence. There's to be no contact with Melinda. Here's the thing. I know she has decided that she no longer wants to prosecute. If you're in a relationship with somebody and you start wanting to search their phone, then that means that there's no trust in your relationship and maybe you shouldn't be in that relationship. I want you to hear me very clearly. You are not allowed to have any contact with her. You all obviously don't have any children together. If you do, you've already told me they're adults. So there's no need to contact her about children because they're adults. It is like you do not know her. If you have contact with her, a motion to revoke is going to be filed and you're looking at potentially 5 years in the prison. Do you understand?
Yes, ma'am.
Is there anything that you do not understand about no contact?
Mm-hmm.
So that means no calling her on the phone, no sending her flowers saying I'm sorry, no sending her something for Friendsgiving or Thanksgiving or Christmas or any of the other holidays that are coming up. Don't send her anything for Valentine's Day. Don't send her thinking of you. No contact whatsoever. You understand?
Yes, sir.
Relationship is over.
Sure.
All right, good luck to you.
It doesn't look like Mr. Stacy has made any progress on the terms of his probation.
And it's saying here that you still have criminal thinking and criminal behaviors. I don't think probation is appropriate for you. You've been given a chance. I know that when you come to this court, if there are issues, you can let the court know. They tried to conduct field visits with you, but that it was a bad address. They made due diligence to contact you through your associations. You didn't show up for your TAP interview. They sent text messages. Text messages were sent to report to avoid a violation. So they were working with you. Email was also sent. It says no response. Then they sent another text message, no response. Then they scheduled a new appointment and sent a text message to you. And yes, you haven't appeared for anything. You haven't done anything. I'm not going to continue you.
Can I address that, Judge?
Yes.
I've talked to my clients and we've discussed that. We've discussed the issues he had while he was on probation. One of the things my client and I, State and I discussed was my client has a decent amount of back time accrued on his case. He and I discussed the possibility how if he were just to get revoked on these cases with his back time, he may be able to get parole sooner rather than later. And he expressed to me that he would prefer for us to go up and ask the court for another chance. And what he expressed to me, I think, was a sincere desire to try to use the services that probation has to try to benefit himself and to try to use those services as opposed to doing a little bit more time flipping out on parole. We understand those services had already been made available to him and he didn't take advantage of them. However, I think him being in custody this time is sort of a wake-up call for him. And I think he has a sincere desire to try to change his life and to try to better his life and sort of break the cycle he was in. So that was sort of my client's thinking, as opposed to possibly taking maybe the easier way out in some aspects and getting flipped out on parole sooner rather than later. He would prefer to wait in jail for a bit, go to therapy and try to address some of these issues in a residential environment with the hope that that would put him on the right path so that he could successfully complete this probation and become a productive member of society.
All right, this is what the court is going to do. In cause number 2022 CR 7131, court is going to grant the motion. This will run concurrent with 2023 CR 0036. Court will order mental health and therapeutic community. You'll need to request that at the prison. It does not increase your length of time that you're in custody, but it can help address other issues you may have. Take in consideration 2024 PF 02689. There's to be no contact and restitution to Andy Nguyen and Ruth Morales. The court is going to sentence you to 2 years in the state jail facility, give you credit for any time served. There's a $500 fine. Time and money will run concurrent. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it? All right, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are in community supervision. Do you understand? All right, next we're going to proceed with 2023 CR 0036. The court is going to grant the motion. The court will sentence you to 4 years in the prison, give you credit for any time served. This will run concurrent with, I'm sorry, what was the previous cause number? 22 731. All right, this will run concurrent with 2022 CR 7131. There's an affirmative finding of family violence. The court will recommend the therapeutic community and mental health unit. There's to be no contact with Melinda Kenney, Kenney. Court will sentence you to 4 years in the prison. I'm sorry, I previously stated that. There's to be restitution and no contact with Andy Nguyen and Ruth Morales in cause number 2024 PF 02689. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. And each of these cause numbers, because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And also in this cause number, you're not allowed to own or possess any weapons or ammunition because there's an affirmative finding of family violence. Do you understand? All right, we can go off the record. So, Mr. Stacy, I understand sometimes people open their minds and that they want to get help after they get a motion to revoke. Probation continually tried to reach out to you to get you back in compliance, and you haven't done anything on probation. At some point in time, consequences have to happen. You understand? All right, good luck to you, okay?
Judge, I don't know if the court already addressed this, but we would request that you get credit for the time he served on both of the cases.
Oh, yes, I gave him credit for it anytime, sir.
We've had the record just running, but we're back addressing the matter of Tina Kaufman. The file number is 241968. Ms. Kaufman is here with Mr. Stickley, the Chief Public Defender. Autumn Kiefer is here. Mr. Stickley, here's what I understand. The defendant was here today for a probation review with a probation officer, Autumn Kiefer. Autumn smelled alcohol, gave the defendant a breath test, and the result was 0.087.
Correct, at 9:40 a.m.
And she drove here. So it is a condition of her probation that, I'll just read it the way it's in the order. It's an old order. She was sentenced to 93 days, credit 2, 91 days to serve, and I deferred a few. So she has 88 jail days hanging over her head. It is a condition of her probation that she take a test upon demand of any police or probation officer. Refusing a test, missing a test, or a positive test will cause an immediate 1-day jail term. And whether potential probation violation consequence. So the defendant got arrested on May 26th, which resulted in this conviction, May 26th of 24. She was in a crash and her blood alcohol was 0.294. She got arrested again on August 7th for drunk driving and file number 241471 SD. Her blood alcohol at that time was 0.244. She was on bond on the earlier case when she got arrested on the second case. Prosecutor dismissed the second case. It was a freebie, and she was placed on probation on this case under the theory that she would be a great sobriety court candidate. However, she moved to Indiana, and we were unable to place her in our sobriety court program because she resides in Indiana. She was placed on a traditional probation. She got arrested for drunk driving again on June 19th in LaGrange County, Indiana, has an arraignment in LaGrange County, Indiana on June 30th. So she is a danger to the public. I don't know what her blood alcohol was. She has a terrible alcohol substance abuse disorder, and she continues to drive. And this is dangerous. Plus, she's legally intoxicated right now, so I can't really even do anything. So I'm going to find a contempt and probation violation. And it's going to be taken into custody, and we'll address this tomorrow when she's sober. Further. Let's see what time we've got tomorrow. Can't really do anything when the person's legally drunk to try to make a record or talk about things. We need to wait till you're sober. About 9 o'clock tomorrow. I'll give you an order. Violation of probation. I don't want to make sure she doesn't get out before tomorrow. Or 2 days jail, credit 0. 2 days to serve. Further hearing 6/25/25 at 9 a.m. Miss Kaufman, do you have pets?
I do.
What do you have?
I have 2 little Pomeranians.
You might want to find somebody to take care of your animals. All right, you're going to jail. I'll see you tomorrow morning at 9 a.m. when you're not at 0.08, and we'll talk further about this.
Your Honor, I'm sure there's protocols at the jail, but just to put everybody on alert, I am concerned about the possibility of some withdrawal issues in the next 24 hours. So if that can be noted or something, make sure that we keep an eye on it.
All right, we'll do that. Michelle's in agreement. Also, you're going to be referred for a new criminal investigation for driving to court while intoxicated. You also were a daily marijuana user. I don't know if you've got marijuana in your system as well or not. But we can't keep going this way. You're going to kill somebody or yourself or both. So I'll talk with you tomorrow. All right. Thank you, Mr.